Your right to refuse is being upheld by the Minnesota Supreme Court. In this ruling issued today, people suspected of driving drunk will no longer be charged with a crime for refusing to take a urine test. The court determined its invasiveness is unconstitutional. And this is now yet another blow to a controversial Minnesota law. Our Joe Augustine's been following the court case for months. So, Joe, break this latest development down for us.
Well, Leah, for a long time, Minnesota law made it a crime to refuse to take a breath, blood, or urine test if you were suspected of driving under the influence. In June, the U.S. Supreme Court ruled the state could still charge people for refusing to take a breath test and did not need a warrant to conduct a breathalyzer. But the highest court also ruled that police do need a warrant to draw blood, and therefore people who refuse to consent to a warrantless blood test are not breaking the law. But they did not rule on the urine test. Well, the state Supreme Court did that today, ruling that a urine test is a lot like a blood test. It involves an invasion of privacy. Therefore, from now on, police in Minnesota need a warrant if they want to test your blood or your urine, and you cannot be charged with a crime if you refuse.
It's good to have clarity because we've been, kind of up in the air for a while, and certainly since June, not sure with regard to blood and urine testing. So this does give us clarity on that.
It's far less obtrusive for law enforcement to say, take this breath test versus, drop your trousers because we're taking a urine test, or roll up your sleeve, I'm going to stick a needle into your vein. And what the courts did was drew this fine line between how much of a privacy invasion is too much.
Now, this could impact a lot of people. According to the State Department of Public Safety, more than 21,000 drivers were tested for impaired driving in 2014. Nearly 3,900 drivers refused a test. Now, if they refused a breath test, those charges will obviously hold up. But if they were charged with refusing a blood or urine test, those charges will now be dropped.
Joe, what if somebody has already been charged or already been convicted of refusing this test that now they're finding is unconstitutional? Then what happens?
Well, it's a good question. I asked the DUI defense attorney about that, and really that doesn't just go away because of the Supreme Court rulings. If you have a conviction on your record, you have to file a petition to have it removed. So if you say, let's say you have a conviction from 10 years ago, now that you're going to have to file that petition to have your record cleared.
Which we'll certainly see some of that happening then.
Yes, absolutely.
All right. Joe, thanks.